some of the same law enforcement involved in the Karen Read case were and are involved in another big case in the Commonwealth of Massachusetts, the case of Brian Walshe. And the court has issued a memorandum on the defense's motion to suppress some of the key evidence. If you were with us before, you know there was some very incriminating searches that Mr. Walshe did. Joining me for this episode is Yoli. So yes, we're going to take a look at a memorandum that came out from the court. If you're new on the Brian Walshe case, accused of first degree in the death of his wife, Anna, this is a good entry to that case. Even if you're not new, we're going to take a look at how the court views the whole thing in this 36-page memorandum. And joining me is Yolie Medina. Hi, Yoli. How are you?
I'm fine. How are you?
I'm good. Before we jump into this, it's 36 pages, but you know how I have a penchant for editing things? It just seemed like every word was important. What were your first impressions before we dive into it?
Well, yeah, you needed to read most of it because it involved 13 search warrants and 2 phone numbers and 2 cars, I think. So it was kind of confusing. So you really needed to read it.
Yeah, and I got up this morning and I said, we can't read this whole thing. We've got to edit it down. So I got my cup of coffee and I sat down and I read it. Then I got another cup of coffee and I said, we can't edit this. I can't do it. I mean, you know, I love to edit stuff. I love to cut stuff out, but it just didn't work. So here it is. This is the memorandum of decision and order on the defendant Brian Walshe's motion to suppress search warrants, ruling on paper number 83. Okay. The defendant, Brian Walshe, or the defendant, has been charged with 1 count of M, 1 count of misleading a police officer, and we'll see what backs that up in a minute, and 1 count of unlawful conveyance of a human body. He moves this court to suppress evidence against him obtained during the execution of 13 search warrants by the Massachusetts State Police, arguing the warrants were not supported by probable cause and were impermissibly broad.
On June 18, 2025, the court held non-evidentiary hearing on the motion. After careful review of the warrants at issue and the arguments of the parties, the court concludes there was probable cause to support search warrants for the defendant's residence and electronic devices, but not for the GPS tracking of his mother's Volkswagen and for some, but not all, of the records sought from his cellular provider. For those reasons, a motion to suppress is allowed in part and denied in part.
And an interesting thing about this, Yoli, I know you know this, but June 18th, 2025 was a really significant day in the world of law in Massachusetts. That was the day that the jury verdict was delivered in the Karen Read case. And so most of us were obsessing over that. Most of us were focusing on that. Most of us were waiting for the verdict and covering the verdict. There was a huge demonstration outside the courthouse. So a lot of people really didn't notice that there was a hearing. Right. The week after that, I finally got around to doing a episode on that hearing. But so that kind of passed everybody by. Background, there are 13 warrants, as Yoli just told us, challenged here. And I'm not going to read the numbers of the warrants. I'm just going to say that the 13 things that the defense was wanting to suppress were the Walshe resident warrant, the warrant on the 2013 Volkswagen Beetle, which belonged to his mother, and a MacBook, another MacBook, that's number 4. Number 5 is an Apple iPad mini belonging to one of his kids. 6, an Apple iPhone 13 mini belonged to one of his other kids. They had 3 kids. Search warrant for a MacBook A2179, another Apple iPhone, color black, an Apple iPad, an Apple iPad 6. The next thing is the Verizon records of cell phone. The next thing is Verizon records of a different cell phone, and they give the numbers there. And the final thing was an iPad. Yoli, I understand that the mother who lived north of Boston, whereas they lived south of Boston, the mother liked to give the kids iPads and iPhones and electronics. There were 3 young children of the Walshes, and so she liked to give them electronic stuff. And as you know, young people love electronic stuff.
Yeah, they do. The court's inquiry as to the sufficiency of the search warrant application always begins and ends with the 4 corners of the affidavit. The facts pertinent to the affidavit at issue here are as follows.
Okay, number 1 is the Walsh residence warrant. Massachusetts State Police Trooper Michael Proctor. That name rings a bell, doesn't it? We should say
Former.
Former or dishonorably discharged Trooper Michael Proctor. But at the time that the motion was filed, I don't know if he had been discharged yet. So anyhow, he had submitted the application for the Walsh residence warrant. Trooper Proctor has 10 years of experience as a police officer and is assigned to the State Police Detective Unit at the Norfolk County District Attorney's Office, NCDAO. He has extensive experience investigating violent crimes and collecting crime scene evidence, and is specially trained in cell tech data and call records used in support of criminal investigations.
The Quincy District Court issued the warrant on January 8th, 2023. The warrant sought A, physiological evidence including hair, skin, blood, brain matter, bodily fluids, bone, and any items that may contain their presence. B, electronic devices including cell phones, iPads, laptops, and other devices capable of communications, custody and control, internet searches, recording, or video surveillance. C, clothing and jewelry described to be worn by Anna. D, Anna's passport, wallet, and cell phone. And E, instruments of the crime, including blunt force objects such as a hammer, knife, hacksaw, trash bags, cleaning supplies, and receipts, or such items and financial documents indicating their purchase. Police executed the warrant on January 8th and 9th, 2023. The affidavit supporting the Walsh resident warrant provided the following information.
On January 5th of 2023, at approximately 3:45 p.m., Cohasset Police notified state police detectives assigned to the Norfolk County District Attorney's Office of a missing person and requested assistance. Cohasset Police reported that the day before, they responded to 516 Chief Justice Cushing Highway, the Walsh residence, after receiving a call from Hugh Dunleavy, the head of security of Tishman Speyer in Washington, D.C., the employer of Anna Walsh, stating that she had not been seen since December 30th. Anna split her time between Massachusetts and Washington, D.C., maintaining a residence in D.C. for work and one in Cohasset with her husband, Brian, and their 3 children. Dunleavy told Cohasset Police that Anna's vehicle was presently at her Washington, D.C. residence. See what I mean? That this document is very thorough, and it gives a lot of background. So people that are not familiar with the case, this is a good introduction to the case, but it also delves into the current legal status.
Yeah. Cohasset Police Officer Gregory Lawrence went to the Walsh resident on January 4th, 2023. Brian was at the house. Brian stated that his wife Anna was missing and he wanted to file a missing person report. According to Brian, Anna had left the Walsh residence between 6 a.m. and 7 a.m. on January 1st, 2023, taking a Lyft or an Uber to Logan Airport in Boston to return to Washington, D.C. for work. Brian had no specific flight information. He explained that despite efforts to reach her, he had not spoken to Anna since the early morning hours of January 1st, 2023. Brian had not contacted the police, but only Anna's employer, who in turn notified Cohasset Police.
Cohasset Police requested and were granted a ping for Anna's cell phone from Verizon. Cohasset Police received data from Verizon at approximately 3:30 in the afternoon on January 4th, 2023, indicating that Anna's phone pinged in the area of Reservoir Road in Cohasset, which encompasses the Walsh residence. The data further indicated that Anna's phone was stationary starting from the evening of December 31st, 2022 until 3:14 a.m. on January 2nd, 2023, at which time the phone went off and did not turn back on. So if they had any suspicions before, now the red flags are going way up with the story that, she had to go back down to Washington, but her cell phone pings locally. So I guess, the red flags are flying.
Right. Washington, D.C. Metro Police performed a well-being check of Anna at her D.C. residence. There were no signs of Anna there, nor any indication of foul play. Further review of Anna's employment records, including her access to her employer's building, video surveillance of the parking garage, corporate credit card transactions, and phone and email activity, showed no indication of any new activity by Anna on January 1st, 2023, or any time thereafter.
Another red flag goes up. The Cohasset police checked domestic and international flight records and found no indication that Anna had booked any travel on January 1st, 2023. Anna had booked a flight from Boston to Washington, D.C. on January 3rd, but she did not board that flight. Cohasset police also requested records from Lyft and Uber. They had no records related to the Walshe residence or Anna's account on the relevant dates. Anna's financial records did not show any activity on January 1st, 2023, or any time thereafter. So notice how, all the electronics track everything we do.
Right.
Flight records, there's a manifest for every flight. Lyft and Uber are both internet-based services, and they do track you. If Andrew Myers calls for a Lyft or an Uber and wants to go to Logan Airport, they have a record of that. So, we're all tracked. Everything we do is tracked.
And what's interesting, later on in this document, they talk about the judge talks about the inference that the cell phone is with the person.
Yes.
That was pretty interesting, because I always would say, you're assuming that the cell phone is with the person. What if the cell phone was left behind? But there's a reasonable inference that can be drawn by that now, because people are so glued to their telephones.
Yeah, the phone is pretty much attached to us these days.
Yeah.
I mean, everybody's phone is attached to them. And if you do leave it behind, one time I did go home and I left my cell phone on my desk. And the minute I got home and reached for my phone and realized that I didn't have it, I turned around and went back to the office. It's not a long drive. And so, You're right. There is an inference that can be rebutted, but there is an inference that our phones are with us. And, you'd think somebody like Anna Walshe, she worked at a really high-end real estate company in Washington, D.C. It's a very high-end company, and she's a professional. She was a professional. And so she would have her phone with her all the time. And if she didn't, she would somehow say, Brian, get my phone down to me,
Yeah. Plus she had kids. So she wanted to make,
3 kids. Yes.
Yeah.
She was a good mother by all accounts, and we're going to see a little bit more of that later in the document. But yeah, we're going to see that, she would want to keep track of those kids. Absolutely.
Yeah. Okay. On January 6, 2023 at 8:30 p.m., Cohasset Police Detective Schmidt and MSP Trooper DeCiccio interviewed Jem Mutlu.
I think you did a good job. I think, Jem Mutlu. I think that's right.
I think that's us. Mutlu had been at the Walshe residence on December 31st, 2022. He stated that he arrived at the residence at approximately 8:30 p.m. and had dinner, champagne, and wine with Brian and Anna. No other adults were present. According to Mutlu, everyone was enjoying themselves and in a good mood. He left the Walshe residence around 1 a.m. to return home.
So on January 6th of 2023, Brian's attorney, Tracy Minor, provided verbal and written consent to turn over Brian's cell phone and 2 Apple iPads. Mass State Police Lieutenant Fanning, here is another Read character. Fanning secured all 3 devices, which the state police forensically extracted at the DA's office and returned to Brian the following day.
Now, is he also part of the Birchmore case or not?
I don't remember.
Sounds
I
familiar.
don't remember if he was. I think he was actually. Yes. It's just coming to me. I remember reading those police reports, and yes, he absolutely was. Good catch.
Okay. On January 7, 2023, Detective Schmidt and troopers DeCiccio and Proctor interviewed Brian at 1:30 p.m. at the Walshe residence. Attorney Minor was present for the interview. Brian stated that on December 31st, 2022, Anna told Brian that she had to fly back to D.C. first thing in the morning, which surprised him. According to Brian, at approximately 6 a.m. on January 1st, 2023, Anna, who was preparing to leave, gave Brian a kiss goodbye and told him to stay in bed since he had to get up with the children soon. Anna was wearing a thin black coat, blue-gray hunter rain boots, and a black floral dress. At around 6:30 a.m., Brian and Anna's oldest child was awake and had asked Anna to fix his iPad. Later that day, around 2:30 p.m., the Walsh's nanny arrived. Shortly after 3 p.m., Brian left the Walshe residence and went to Shaw's supermarket to purchase milk and orange juice. He returned home, placed the groceries in the fridge, and left again around 4 p.m. to head to his mother's residence in Swampscott. The ride took longer than usual because Brian got lost. Normally, he would use his cell phone GPS for directions, but one of his children had taken his phone on December 31st, 2022, and he did not find it until January 2nd, 2023. Okay. He did not know how to use the Volvo's GPS. Brian stated that he took Route 3 north to Route 93 north and Route 1 north. He realized he was lost when he observed the pirate ship on Route 1.
Yeah, that's way up the road. I think it's in Danvers. So I'm sorry.
Yeah, that's okay. Then he took Route 114 to his mother's house. Brian arrived at his mother's house at around 5:30 p.m. and stayed for approximately 15 minutes. He then went to the Swampscott Whole Foods, where he purchased frozen foods for his mother, and the CVS in Swampscott, where he purchased alcohol wipes for his mother. He returned home at 8 p.m.
You know, this is all according to him, and he's giving these statements to police with his lawyer's approval. And I tell people don't personalize, but that makes no sense. All those roads are major roads, Yoli. Route 3 is like an interstate. It's a 4-lane divided highway. 93 is the same, and Route 1 is the same. Now,
he's been to his mother's house before, right?
Well, that's my point. He's going from his house in Cohasset, which is just south of Boston, to Swampscott, which is just north of Boston, but it's inside the Route 128 belt. So he's driving through the city, which can be confusing if you're not from this area. But yeah, you're right. He's going from his house to his mother's house. Now, some of the streets in Swampscott itself can be confusing, but it's his mother's house. So I don't know. That makes no sense.
That doesn't make any sense.
No.
And his lawyer is
sitting there while he's spinning a yarn, as we're going to see in a minute. State Police Trooper Kutkowski reviewed the video at the Swampscott and Salem CVS stores from 4:40 p.m. through 8:30 p.m. He did not observe Brian enter the stores, and neither CVS had a record for a purchase of alcohol wipes on January 1st, 2023. During that time frame, video footage from the Swampscott Whole Foods also did not show Brian enter the store, and neither his Chase nor Fidelity credit cards showed any purchases at Whole Foods. See what I mean about how we are tracked? Every single thing we do is tracked or not tracked in this case.
Well, why would you say that? You know that there's cameras there. I mean, it just sounds really stupid.
And why would you say anything at all? I mean, wouldn't your attorney have advised you that you have a Fifth Amendment right not to say anything to the officers?
Whether he's going to follow it is a different story. Some people want to do what they want to do.
Right. I agree. And I've seen it.
They think they're right and they don't care what their attorney says. They just want an attorney there just in case.
I had a client one time tell me, I'm going to go down to that police department and straighten them out. And the indictment wasn't that long after that.
Oh, God.
Anyhow.
Yeah. During the January 7, 2023 interview, police questioned Brian on why he did not contact law enforcement about Anna being missing. He said that his phone went missing on December 31st, 2022, and that he emailed his mother and business partners the next day sharing that information. According to Brian, he found his phone in his 6-year-old son's bed on January 2nd, 2023. That day, he sent Anna multiple messages stating that he was worried and asking where she was. On January 2nd and 3rd, 2023, he texted family and friends asking if they had heard from Anna. Brian said he did not become concerned about Anna until January 2nd, 2023. Recently, Anna had been unreachable for about 24 hours when she was coming home for Christmas. When Brian had told her he had been concerned and almost called her work to ask about her whereabouts, Anna had instructed him not to worry and that she did not want any issues at her workplace. For this reason, Brian had not reported that Anna was missing until Cohasset police arrived at the Walshe residence on January 4th, 2023.
Okay, here's two more. Here are two more Karen Read characters. Mass State Police Troopers Nicholas Garino, remember him? He was the tech expert. And then Connor Keefe conducted a forensic review of the data extracted from the iPad mini that Brian had given to Lieutenant Fanning. On January 1st, 2023, Brian's cell phone was manually unlocked. The password for the phone was entered at 7:57 a.m., 11:24 a.m., 12:39 a.m., and 12:46 a.m. The forensic review revealed the following internet searches. And we have to go down into the footnote and point out that the iPad we're talking about here was an iPad mini, which Brian said belonged to his 6-year-old son. So these are the searches that were made on the son's iPad. January 27th, I don't know why they're jumping that far ahead, but January 27th, 2023 at 9:54, best state to divorce for a man. The next sequence, these are all January 1st, 2023, starting at 4:55 a.m. Bear in mind the timeline that their friend who was there for the New Year's Eve, get together left at around 1 o'clock. So 3 hours and 55 minutes later, Mr. Walshe is searching how long before a body starts to smell. Right after that, how to stop a body from decomposing. Right after that, how to embalm a body. Right after that, 10 ways to dispose of a dead body if you really needed to. He comes back at 6:25. How long for someone to be missing to inheritance? 6:33, Cohasset dump. 6:34, Hingham dump. 6:34, can you throw away body parts? So there's a break from 6:34 until 9:29. What does formaldehyde do? Right after that, how long does DNA last? 9:59, can identification be made on partial human remains? Little break until 11:30. We're still on New Year's Day. Dismemberment and best ways to dispose of a body. How to clean blood from wood and floor. Luminol to detect blood. Then there's a break until just after 1 o'clock. What happened when you put body parts in ammonia? And 121, the last in this series, is it better to throw away crime scene clothes or wash them? So Trooper Proctor averred that there was probable cause to believe that Brian committed the crimes of kidnapping and misleading a police investigation based upon the foregoing facts, including Brian's inconsistent statements, internet searches, and the fact that Anna had not been located, nor had there been any activity of her accounts.
Wow, what a day to spend your New Year's Day, huh?
Yeah, and I mean, so obviously, things happened between 1 o'clock when their friend left, and then the first searches are at 4:55. I mean, oh, good grief.
Terrible. Okay, Volkswagen warrant. Trooper Proctor submitted the affidavit for the Volkswagen warrant. The application sought installation of GPS tracking on the vehicle registered to Diana Walshe, Brian's mother, and in the possession of Brian. The Quincy District Court issued the warrant on January 8, 2023.
The warrant affidavit set forth the exact same facts as in the Walshe residence warrant affidavit. It further offered information about the use of GPS surveillance tracking systems, specifically Mass State Police Lieutenant David Kraus, the electronic surveillance equipment technician assigned to the Special Services section of the Mass State Police, had informed Trooper Proctor that GPS surveillance systems are installed on a target vehicle without the target's knowledge, and they calculate the position utilizing satellites orbiting the Earth. Law enforcement can obtain the position of the target vehicle using mapping software through a cell phone installed in the vehicle and may obtain current as well as historical locations of the vehicle.
Interesting, though, in the footnote, it said that Proctor had the wrong date on numerous affidavits or something. Yeah.
Yeah, good catch.
Yeah, he's on more than one. He's had the wrong date on them. And I see these errors on these affidavits, and I guess I don't know if they're common or if it's just these police officers who are not careful are making these mistakes. But I would think a date would be very important.
Well, it's crucial. And the other thing is that, we all make typos. We all make mistakes. It's, but in a case like this, in a first degree M case, wouldn't you think you'd have an office assistant or another police officer or someone that, you're working together with? I mean, we've already talked about at least a half a dozen troopers looking at this case. And, isn't somebody,
because how do they know? How do they know it's a mistake?
Yeah. True.
The court is saying he made a mistake, but unless it's in the affidavit, how does the court know that February 9th was an erroneous date when it should have been back in January?
Attention to detail is a really important thing. I remember going all the way back to the LSAT. Do they require the LSAT in California? And what a pain in the neck. If you want to go to law school, I think some of the schools have got, but they really hammer in on the fact that details are important. And if you get details wrong on an LSAT test, you get that answer is wrong. Go on to the next one and pay better attention to the details. So yes, details are important. I mean, if you're playing, think of it this way. If you're playing a symphony and instead of playing a C, you hit a D, it's going to be terrible.
Yeah.
So anyhow, based
Okay.
upon the facts in the affidavit, Trooper Proctor averred that there was probable cause to believe that Brian had access to and the ability to operate 3 vehicles currently in the driveway of the Walshe residence, including the Volkswagen registered to his mother, and that Brian may be a flight risk. Trooper Proctor further averred that there was probable cause to believe Brian committed the crimes of kidnapping and misleading the police investigation, and the use of the GPS device would enhance the investigation by quickly identifying locations, durations of stops, and frequencies of locations visited by Brian.
Okay, so this is the MacBook A1534 warrant, MacBook A2159 warrant, iPad 6 mini warrant, red iPhone warrant, Mac A2179 warrant, black iPhone warrant, iPad A2603 warrant, and iPad 6 warrant, collectively the electronic devices, which is what I should have said.
Yes.
That whole thing. All right, so police recovered the various electronic devices that were the subject of the warrants from the Walshe residence during their execution of the Walshe residence warrant. MSP Trooper Nicholas Guarino submitted the affidavits for the electronic devices warrants. Trooper Guarino has 17 years in law enforcement. He has specialized in the analysis and data extraction of cell phones using the Celebrite software system and in X-Ways forensic software, Axiom magnet forensic software, and autopsy forensic program software or software programs that analyze extracted data from digital devices. Trooper Guarino conferred with MSP Sergeant Edward Keefe during the investigation. Sergeant Keefe also has specialized training in mobile device extraction and analysis, as well as computer and cell phone forensics, GPS forensics, and advanced data extraction. He holds a certificate from International Association of Computer Investigative Specialists as a forensic computer examiner and mobile device examiner.
Okay, so the Quincy District Court, which is just south of Boston, issued the electronic devices warrants on January 9th of 2023. The warrants all sought A, documents, photos, audio visuals, files, electronic communications, emails, accounts, web browser history, searched topics, contacts, usernames, passwords, deleted data, significant or cached locations, and GPS location data from Sunday, December 25th, 2022 at 0 hours through until Sunday, January 8th, 2023 at 0900 hours related to the disappearance of Anna and the misleading of the police investigation. B, any user data related to specified Apple IDs. C, any notes, journals, Word text documents regarding Brian's activities during this investigation from December 25th, 2022 at 0 hours to Sunday, January 8th, 2023 at 0900 hours. Call logs from the same time period. Chats, texts, and other messages from communications applications from, again, that same time period from December 25th through Sunday, January 8th. F, health diagnostic data from December 31st, 2022 at 0 hours to Sunday, January 8th, 2023 at 9 o'clock. And G, information showing ownership, custody, or control of the electronic devices. Police executed the warrants on January 9th of 2023.
Okay. The affidavit supporting the warrant set forth information Trooper Garino gathered during his investigation, as well as information he learned from other MSP troopers and detectives and Cohasset police. And again, Garino, go up to the footnote. Garino dated, Trooper Garino also incorrectly listed February 9th as a date he submitted the affidavits for electronic device warrants.
I always tell my viewers the footnotes are important, but you're the one that caught it in this one. I just kind of skipped them. So
That's
good catch,
bizarre.
good catch. A lot of mistakes on the dates.
Yeah. And how do they know it's a mistake? I guess they know because those search warrants were served
I
before.
think, and the other thing is that remember that this is an order that came out in late July, and there had been a hearing way back in June 18th, and I frankly don't recall whether those errors were identified during that hearing.
Could be.
Yeah. So that's my guess.
Okay.
On January 4th of 2023 at about 6:35 p.m., Detective Schmidt arrived at the Walshe residence for a follow-up investigation, at which time he conducted an audio recorded interview with Brian. At the conclusion of the interview, Brian consented to a search of the house and surrounding property. Brian led Detective Schmidt around the residence and property and identified items of potential interest in the missing person investigation. Before leaving the scene, Detective Schmidt observed the back of a 2019 Volvo bearing the mass registration 8NR793 with the third row raised. Lining the floor of the trunk area was an opaque, off-white, thin piece of plastic. The next day, Detective Schmidt went back and re-interviewed Brian. At the conclusion of the interview, Brian consented to a search of the Volvo. The third row seat was now folded down, and floor mats were laid on the floor of the trunk. There was light brown dirt on the floor mats. The carpet on the floor of the truck appeared freshly vacuumed. When Detective Schmidt asked Brian where the plastic trunk liner was from the night before, he stated that he had put it in the trash cans.
On the morning of January 7, 2023 at 5:18 a.m., Cohasset Police Detective Schmidt received an email from Richard Walker 998@gmail.com stating the following. We have the so-named Anna Walshe with us here. We had a deal worth $127,000. She messed up. We have her here with us, and if she doesn't pay the money, then she'll never be back. And we know that the police and the FBI are involved. Good luck finding us. Okay. Partial ellipses in the original. Investigators considered this email suspicious because it contained no timeline to respond to the demand and no contact instructions.
Yeah, it's just kind of shady, if you ask me. It's not much of a demand letter. It's really, I mean, remember in the old days, or am I showing my age, that before there were word processors, and one of the specialties way back then was every typewriter was unique. If you and I bought exactly the same make and model of a typewriter, your letters printed out and my letters printed out would be different. And so way back then, a lot of times criminals would make their demand letters by cutting out letters from a magazine. Remember that?
Yep. I am old enough to remember that, but just barely.
Okay. All right.
I had a typewriter in high school. Put it that way. I had a typewriter in high school. So.
Yeah, well, I was banging out hieroglyphics on a rock. But anyhow, we'll get back to the case. On January 7th of 2023, Trooper Connor Keefe analyzed location information extracted from Brian's cell phone utilizing the Celebrite physical analyzer. During an interview earlier that day, Brian had told investigators that the only place he visited on January 2nd was an ice cream shop in Norwell called Press. However, location data from Brian's phone showed that on January 2nd, 2023, at 4:12 p.m., Brian's cell phone was at the Home Depot in Rockland until about 4:56 p.m.
On January 8th, MSP Trooper Moore traveled to the Rockland Home Depot to review security video from January 2nd, 2023. The footage showed that between 4:12 p.m. and 4:56 p.m., Brian was pushing a shopping cart containing cleaning products, including 3 mops and brushes, 2 large clear tarps, a drop cloth, 2 rolls of heavy-duty tape, a Tyvek suit with hood, boot, and coverall, and a mop bucket with wringer.
Okay, well, I guess you could argue your way out of the mops and brushes, but how do you explain the Tyvek suit? That would be a tough one. So on January 8th of 2023, police executed the Walshe residence warrant. Located in the basement was an unopened 10 by 20 foot heavy-duty canopy tarp, which appeared on an itemized receipt that Home Depot had provided Trooper Moore. Police also discovered a roll of plastic consistent with the plastic Detective Schmidt observed in the back of Brian's Volvo on January 4th. Police seized numerous electronic devices from the home, including 3 MacBooks, 2 iPhones, and 3 iPads.
During the 4 occasions, police interviewed Brian between January 4th, 2023 and January 8th, 2023. He gave statements regarding a trip to Whole Foods and CVS in Soamscott that the officers interpreted as willful attempts to mislead investigators. The statements wasted resources and delayed the search for Anna. Further investigators identified multiple instances where Brian, who was on federal probation monitoring that required him to request leave his residence, traveled to locations that he did not disclose to his probation officer. So he was on probation for some federal thing, right?
Yeah, what happened was this. He had posed himself as some kind of a fine arts dealer. And he sold some Andy Warhol prints for $80,000, shipped them from Greater Boston to California. Maybe one of your neighbors, I don't know. When the guy got them in California, he looked at them and determined they were phony. He sold phony prints. That what he had done is he actually knew the person who owned the original, and he somehow, through some high-tech photographic technique, duplicated it onto, some new mat. And so he sold these phonies for $80,000.
Wow.
And he was prosecuted for fraud in the federal court in Boston. And then he had been convicted, I believe, if I'm not mistaken, on 4 different counts: wire fraud and, selling the fraudulent paintings themselves. There were 4 counts. And his sentencing was pending at the time of this, at the time of Anna's disappearance on January 1st of 2023. And because he had been convicted, but the sentencing was pending, he had an ankle bracelet on and he was under probation and he wasn't to go anywhere without telling his probation officer. So that's where that comes from. But you know what else comes to me? And I don't want to draw this out too much because I know we have a lot more reading to do, but a lot of people have a misunderstanding about the Fifth Amendment. The Fifth Amendment allows one to remain silent. One has no obligation to speak to law enforcement. However, that doesn't mean you can lie to law enforcement. You can refuse to speak. But if you do speak, you must be truthful and honest and tell the truth. It doesn't allow you to fib and make up stories, which is apparently what the charges are here against Mr. Walshe. Based upon the facts in the affidavits supporting the electronic devices warrants, Trooper Garino averred that there was probable cause to believe that Brian committed the crimes of kidnapping, misleading a police investigation, and there you go, that's what I was just talking about, and disinterring a body.
Okay, based on Trooper Garino's training and experience and information he learned by conferring with Sergeant Keefe, the affidavit also set forth the capabilities of electronic devices and particularly Apple products. According to Trooper Garino, electronic devices are capable of conducting internet searches, storing large amounts of data, and connecting to external devices via universal serial bus cable and Bluetooth signals. Apple computers, cell phones, and tablets have the capability of sharing files between one another using Bluetooth signals. Apple devices which share the same Apple ID will share information such as internet searches across those devices signed in through Apple iCloud services. The Apple iPhone can be paired with a smartwatch or a fitness tracker that will record distance traveled, heart rate, and calories burned. An iPhone can also store financial information and be used to make purchases at select locations.
Our entire lives are on our electronic devices.
Right.
Whether you have an Android or an iPhone, our entire lives are on there. Trooper Garino further averred that based on the officers' training and experience, they know that people who commit criminal offenses often communicate prior to and following a crime and often communicate with their victims prior to and following. Well, this is all opinion. People also often transport portable devices from location to location, and the devices connect to various Wi-Fi connections with ease. A search of an electronic device may reveal log files and file remnants concerning communications, use of internet service accounts, as well as internet access to various websites. According to Trooper Garino, it was reasonable to believe in this case that electronic devices were accessed to communicate with others before, during, and after the commission of the suspected crimes.
Lastly, Trooper Garino averred that the historical GPS data associated with the electronic devices would contain evidence of the physical location of the devices. According to Trooper Garino, the information and evidence associated with a particular device would contribute to identifying the locations from which the device departed, where it traveled, and the time it remained at various coordinates. The devices would also store subscriber information as well as telephone numbers recently dialed, calls received, and information related to contacts. Trooper Garino believed obtaining access to the electronic devices would materially aid the investigation.
So now we get to the iPad A1474 warrant. Trooper Garino submitted the application for the iPad warrant, and the Quincy District Court issued the warrant on March 9th of 2023. Police recovered the iPad from Anna's residence in Washington, D.C. The warrant sought documents, photos, videos, audiovisuals, files, electronic communications, and all this other stuff, data from Thursday, November 17th. So now we're going way back to before Thanksgiving, all the way through Saturday, January 7th, 2023, at about 12:50. Related to the disappearance and murder of Anna and Brian's misleading of the police investigation. B, any user data related to specified Apple IDs. C, FaceTime calls and logs from Thursday, November. There's that long time period again. D, information showing ownership, custody, or control of the electronic evidence items. E, any communications between Anna and Brian, other family members or friends from that same time period. And F, communications and records relating to Anna and Brian's states of mind or motive, including financial records, life insurance policies, divorce, child custody disputes, or marital discord. And now I'm going to go back and peek at that. Oh, look at that. You've trained me well. Footnote 11. As with the other warrant affidavits in this case drafted by Trooper Guarino, this affidavit stated an incorrect date of submission, post-dating the date of the issuance and search. Interesting.
Yeah. The warrant affidavit reiterates facts from previous Walsh resident warrant affidavits and affidavits supporting the electronic device warrants, including information about what information can be gleaned from electronic devices. The affidavit contained the following additional information.
In addition to the internet searches occurring on December 27th, 2022 and January 1st, 2023 that were extracted from the iPad mini belonging to Anna and Brian's son, who I believe was 6 years old, a search of that iPad mini revealed other internet searches conducted on January 2nd and 3rd. These included, and I'm not going to give all the times, but they're January 2nd and 3rd. You know, most people are enjoying the new year, but here are the searches. Hacksaw, the best tool for dismembering a body. Can you be charged with murder without a body? Can you identify a body with broken teeth? What happens to hair on a dead body? What is the rate decomposition of a body found in plastic bag compared to body found on surface in the woods? Can baking soda make a body smell good? Several of the internet searches conducted on January 1st occurred prior to the time Brian stated he had last received a kiss from his wife before she left the Walsh residence. The searches for how long before a body starts to smell and how to stop a body from decomposing occurred less than 4 hours after the time when Anna was last seen alive at the Walsh residence by Mutlu.
On January 7th, Trooper Keefe analyzed location information extracted from Brian's cell phone utilizing Celebrite software. It showed that on January 2nd, 2023 at 9:44 a.m., the device was in the area of Home Goods in Norwell. Surveillance footage from Norwell Home Goods showed Brian pushing a shopping cart and purchasing 3 rugs among other items. Later in the day, Trooper Moore observed video footage from the Rockland Home Depot showing Brian purchasing several items, including 2 splash-resistant goggles, a soft grip utility knife, 2 12-pound bags of baking soda, and a hatchet.
You know, I have some baking soda in my kitchen, but it's in those little boxes that I don't know how many ounces. It's a little box, but I don't know what the valid reason would be to be buying a 12-pound bag of baking soda, much less 2 of them.
I guess he thinks that's going to help the smell. I don't know.
Yeah. Okay. Brian's cell phone location data showed that after leaving the Home Depot, he made a trip to Derby Street in Hingham, lasting from 5:15 p.m. to 5:32 p.m. Video footage shows Brian left the jacket, black face mask, and the blue rubber gloves he was wearing while at Home Depot in his car, walked to a trash can on Derby Street, and discarded small trash bags.
Okay. Location data also shows that on January 3rd, 2023, Brian's cell phone was in the area of the Claremont apartment complex in Abington from 4:27 p.m. to 4:39 p.m. Investigators observed video from the area showing a man consistent with Brian's appearance exit Brian's Volvo and walk toward the dumpster carrying a garbage bag that appeared to be of significant weight. Subsequently, at approximately 4:48 to 4:52 p.m., Brian's device was in the area of the Point apartment complex in Abington, but there was no video of the dumpster area. Brian's device then went to the area of the Chatham West apartment complex in Brockton from 5:15 p.m. to 5:16 p.m. Video from that area shows a man consistent with Brian's appearance exiting the Brian's Volvo and discarding items in a dumpster. Investigators worked to track the dumpsters at the various locations, but the items had already been shredded or incinerated by the evening of January 8th, 2023.
On January 8th of 2023, while executing the Walsh residence warrant, state police members assigned to the crime scene services section and members of the state crime lab conducted testing on various surfaces and floors within the home. Multiple locations in the basement and staircase leading down to the basement tested positive for blood. A knife that tested positive for blood was located next to multiple bottles of hydrogen peroxide inside a cabinet above the kitchen's refrigerator.
On January 8, 2023, Detective Schmidt and Troopers DiCiccio and Garino interviewed Brian at the Walsh residence. Attorney Minor was present for the interview. During the interview, Brian stated that on January 1st, 2023, he went to the CVS in Danvers. Investigators observed Brian on video at the Danvers CVS purchasing and shoplifting cleaning products.
Why would he shoplift this stuff? Isn't he in enough trouble already? I mean, you go to a CVS store and you feel like you're in a TV studio. There's bright lights in there. There's obvious cameras in the ceilings. Why? I'm shaking my head at this. I'm sorry, I interrupted you. Go ahead.
It's okay. The officers confronted Brian with the iPad searches about dismembering and disposing of a body conducted prior to the time he stated that he last saw Anna at the home. Brian offered no explanation other than the iPad belonged to his son. Trooper DiCiccio asked if Brian's 6-year-old son was of average intelligence, and Brian stated, "I'd like to think so." When told the searches had no misspelled words, he offered no explanation. Attorney Minor offered the possibility that Anna had performed some of the searches on the iPad herself. When asked to explain how the searches continued after Anna was said to have left the home, Brian offered no explanation. Attorney Minor then terminated the interview. Yeah, he should have done that a long time ago.
I'm sorry, go ahead. What'd you say?
He should have done that a long time ago.
Why did she even allow the interview? Good grief. The same day, police arrested Brian and charged him for intentionally misleading a police investigation. So that would have been January 8th. And since that was only one sentence, I'll read the next paragraph too. On January 9th, 2023, investigators executed a search warrant on Brian's Volvo. Swabs taken from the weather mat in the trunk of the vehicle and the electronic adjustment buttons along the driver's seat indicated the presence of blood.
The same day, investigators continued to review Brian's cell phone data. They observed that on January 5th, 2023, Brian traveled to where his mother resides, but unlike a previous visit on December 27th, 2022, this time he remained in the southwest corner of the complex near the dumpster for 5 minutes before leaving. MSP Trooper Kowski secured the dumpster. A search revealed 10 trash bags. The contents were documented, bagged as evidence, and secured. Among the items secured were towels, rags, slippers, plastic sheeting, tape, a Tyvek suit, gloves, cleaning agents, carpet rugs, hunter boots, a Prada purse, foreign currency, Anna's COVID vaccination card, a hacksaw, a hatchet, heavy-duty cutting shears, and a hammer. The boots and purse were consistent with what Brian had described as Anna possessing when he last saw her on January 1st, 2023. Many items contained red-brown stains consistent with blood. Preliminary testing on a portion of a rug, which was heavily stained and red and brown in color, showed substance consistent with baking soda. Scrapings from the rug also revealed a metal bar with the name Gucci imprinted on it, consistent with a necklace that Anna wore in photos.
The state crime lab performed testing on selected items secured from the dumpster. The slippers, the Tyvek suit, and a tissue showed the presence of DNA. Further testing of the DNA from the slippers and the sleeve cups of the Tyvek suit matched Anna with Brian as a contributor. DNA testing of the exterior left pant leg and the interior right sleeve of the Tyvek suit and from the tissue included Anna as a contributor. So I don't know. I just gotta stop here for a second because people say, and it's true, at least it was in the old days when we were still in the, cutting letters out of magazine days. you know, if you didn't have a body, you would, and I remember reading Ann Rule's cases years ago. If prosecutors didn't have a body, it was a tough case to prosecute. But now in 2025, you've got DNA along with all the other stuff in context, the Tyvek suit, the hacksaw, all the other stuff. DNA is kind of, everybody's entitled to the presumption of innocence. Everyone is entitled to the presumption of innocence until and unless found guilty by a jury. But that DNA evidence sure overcomes not having a body, in my opinion.
Yeah, depending on how it was done, but this is not like some kind of genetic investigative genealogy that they use to try to get this DNA. This is actually blood DNA.
Yes.
Tissues. So, they had blood mixture of Anna as a contributor and also Brian. So
yeah, it's a body fluid. It's a body fluid. It's not like a couple of different skin cells as in a different case that we've talked about in the past. The information collected during the investigation caused police to suspect that Brian killed Anna, dismembered her body in the basement of the Walshe residence, and disposed of her body and other items in various dumpsters. This information included the internet searches, untruthful statements, presence of blood in the basement, Brian's purchase of cleaning supplies and cutting instruments, the presence of blood in the rear of Brian's Volvo, video evidence of his multiple trips to 6 dumpsters in 5 days, and the items recovered from the dumpster in Swampscott. Investigators interviewed many of Anna's close friends, colleagues, sister, and mother. No one has heard from her since the early morning hours of January 1st, 2023. There was no indication that she would have voluntarily disappeared. She had made future plans for herself, professionally and personally, and for her children.
This is Verizon warrants. Trooper Connor Keefe submitted the applications for the Verizon warrants. Trooper Keefe had been assigned to the State Police Detective Unit in the NCDAO since January 2021. He has specialized training and experience in the collection of physical evidence, crime scene processing, and the investigation of cases.
Trooper Keefe submitted the application for the Verizon warrant on January 20th, 2023, and the district court in Quincy issued the warrant that same day. He submitted the application for the other Verizon account on February 3rd, and the Quincy district court issued that warrant the same day as well. Both applications sought call detail records, location information, subscriber information, network data usage or internet protocol usage data, and list information pertaining to cell towers or the respective phone numbers. The records sought for the Verizon 8646 warrant were from December 30th at 12 a.m. through January 8th, 2023 at 11:59 p.m. The records sought were for the Verizon 8028 warrant were from January 1st, 2023 at 12 a.m. through January 8th at 11:59 p.m.
The affidavits supporting the Verizon warrants indicated that Brian used both cell phones since Anna's disappearance. For instance, according to the Verizon 8646 warrant, Brian used that cell phone on January 2nd, 2023 to make an outgoing call, and the phone was with him when he traveled to the Rockland Home Depot to purchase items that police believed he used to dispose of Anna's body. According to the Verizon 8028 warrant, Brian had that phone with him on January 1st, 2023, when police observed him on surveillance footage at Lowe's purchasing over $450 worth of tools, including a hacksaw, as well as cleaning supplies. Another trip that Brian had not disclosed to investigators.
Interesting. It's getting deeper. The affidavits supporting the Verizon warrants reiterated information from the previous affidavits learned during the interviews of Brian. The initial investigation upon the report of a missing person, the consented to search of the iPhone and iPad mini, the search warrant of Brian's Volvo, the location data, and subsequent observation of Brian's actions from January 1st, 2023 to January 8th, 2023, and the items recovered from the dumpster in Swampscott. The affidavits contained the following additional information.
During the police interview of Mutlu on January 6, 2023, he stated that he sent Brian and Anna a message on the same text thread on January 1st, 2023 at 11:40 a.m. Anna never responded, and Brian responded on January 2nd, 2023, telling Mutlu that his child had just found his phone. On January 4th, 2023, Brian called Mutlu and sounded distraught and a little off. Brian told Mutlu that he had not heard from Anna in 3 days and that she had left early in the morning for a work emergency. Mutlu asked Brian if he and Anna had an argument after he had left, and Brian responded something to the effect of, "Did it look like we were arguing?" Mutlu provided to the police the names of people who knew Anna well, including her friends Alyssa Kirby and Will Fastow.
On January 7th, 2023, Mass State Police Sergeant Yolie Medina, another Read figure. Buchanan and Detective Lopes traveled to Washington, D.C. and spoke to Fastow with his attorneys present. Fastow resides in D.C. and was the most frequent contact with Anna on the cell phone records in possession of investigators. Fastow told investigators that he had been dating Anna for several months and that the relationship had become more serious over the past few months. Fastow and Anna had spent Thanksgiving and Christmas Eve together. They were open about their relationship in D.C. and had plans to celebrate the new year on January 4th, 2022, when Anna returned from Massachusetts.
The plot thickens.
Doesn't it?
Investigators also spoke with Kirby. She told them that Anna and Brian's marriage was strained and that Anna was planning on having the kids live with her in D.C. Anna had reportedly given some sort of ultimatum to Brian about the resolution of his federal criminal case and wanted the kids to be with her. When investigators viewed Anna's residence in D.C., they observed it to be ready for the kids to move in with their clothes and other items present.
A little detail that is not in, as if there's not enough in this memorandum, but a little detail that has come out elsewhere is that apparently Brian had his mother, or Brian through his mother, had hired a private investigator to tail Anna in Washington, D.C.
Oh.
Getting back to the four corners of this document, the affidavit supporting the Verizon 8028 warrant contained the following additional information not found in the affidavit for the Verizon 8028 warrant.
Investigators interviewed the Walsh's nanny, Robin Howe. Howe told police that Brian asked her to watch the children on January 1st, 2023 from 2 p.m. until 7 p.m. Brian had previously told Howe that he and Anna were going to a brunch that day, but when Howe arrived, he said Anna had to return to Washington, D.C. for a work emergency and he had errands to do. She observed that Brian, who was generally calm and collected, appeared preoccupied that day. He left around 2 p.m. and returned between 4 p.m. and 5 p.m. to drop off pizza and then went out again. Howe observed one of the children had a new iPad. She said that Brian's mother, Diana, was always buying new iPads and iPhones for the children. Brian returned between 8 p.m. and 8:30 p.m.
After further investigation, investigators discovered the iPhone with the phone number ending in 8028 was present at Home Goods in Norwell on January 2nd, 2023, when Brian was seen on surveillance video purchasing 3 rugs and other items and at Press Juice Bar, although Brian stated that he had lost or misplaced his iPhone 13 on December 31st and did not find it until January 2nd. He had the care, custody, and control of the iPhone ending in 8028.
The affidavit supporting both the Verizon warrants explained that based on Trooper Keefe's training and experience, he knows people frequently employ cell phones as a primary means of communication, and suspects involved in criminal behavior oftentimes require communications. Such communication is essential to evading police and disposing of evidence. Trooper Keefe believed that the records related to the mobile devices used by Brian ending in 8646 and 8028, relevant to the period preceding and following Anna's murder, would provide evidence of planning, execution, and a cover-up of a crime.
Trooper Keefe also explained that based on his training and experience, cell phone providers can provide an estimated distance between a cell phone and a cell site, and modern civil phones contain GPS receivers which can provide the latitude and longitude of the device when certain functions are performed. According to Trooper Keefe, obtaining records from Verizon would allow investigators to confirm or refute Brian's movements during the planning, execution, and disposal of evidence, assist in establishing a timeline, and identifying other possible locations where evidence may have been disposed.
Discussion. This is the discussion part of the brief. It's our order. Under the Fourth Amendment and Article 14th, a search warrant may issue only on a showing of probable cause. For probable cause to arise, the facts contained in an affidavit, plus the reasonable inferences that may be drawn from them, must allow the magistrate to determine that the items sought are related to the criminal activity under investigation and that they reasonably may be expected to be located in the place to be searched at the time the search warrant issues. In dealing with probable cause, as the very name implies, courts deal with probabilities. These are not technical. They are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act.
In reviewing a finding of probable cause, search warrant affidavits are to be interpreted in a realistic and common sense manner and should be read as a whole, not parsed, severed, and subjected to hypercritical analysis. An inference drawn from the affidavit, if not forbidden by some rule of law, need only be reasonable and possible. It need not be necessary or inescapable. Moreover, a reviewing court gives considerable deference to the magistrate's determination of probable cause, and even the resolution of doubtful or marginal cases should be largely determined by the preference to be accorded to warrants.
And one thing I want to say about that is a lot of people think that when people plead the fifth or they refuse to speak, that somehow makes them suspicious. But that is not the case. They have a right to do that. And
Absolutely.
so even
Absolutely.
Yeah, and even if somebody is on the stand and they plead the fifth, for example, the jury will be instructed not to infer anything from that, that they are involved or anything like that. So that's one thing that I wanted to point out, because a lot of people.
No, you're absolutely right. You're absolutely right to point that out, because a lot of people misunderstand that. And again, to amplify a point I kind of alluded to earlier, you have an absolute right, and the court may draw no inferences at this stage with regard to your claiming your right against self-incrimination. But that does not allow you to just go to the police department and, just state, absolute fabrications like he did in this case. He said he went to the CVS store and the Whole Foods store, and that caused the police to invest their resources in going to those places and determining that that was an outright lie or a fabrication or whatever you want to call it. So
Right.
You're right about the Fifth Amendment. However, people out there that think that also allows them to take the extra step and start making stuff up. Nuh-uh.
Right. Okay, now the Walshe residence warrant. The defendant contends that the Walshe residence warrant was not supported by probable cause because the affidavit in support of the warrant failed to establish a nexus between the items sought and any criminal activity. He also argues that insofar as the warrant authorized the seizure of all electronic devices in the Walshe residence, it was impermissibly broad. Based on careful review of the warrant affidavit, the court concludes there was probable cause to search the Walshe residence for the specific items, including all electronic devices.
As to the defendant's first contention, it is well established that the affidavit submitted with the search warrant application must provide a, quote, substantial basis to conclude that the items sought are related to the criminal activity under investigation, and that they reasonably may be expected to be located in the place to be searched at the time the search warrant issues, unquote. Stated differently, the government must show not only that there is probable cause that the individual committed the crime, but also that there is a nexus, a connection between the alleged crime and the article to be searched and seized.
The affidavit here showed that Brian had not contacted police even though his wife had been missing for several days, and that his account of what occurred on January 1st, 2023 did not match the other information investigators had obtained. There was no evidence that Anna had left the Walshe residence in an Uber or Lyft to fly to Washington, D.C., as Brian claimed, or that she ever planned to do so. And surveillance footage and store records contradicted Brian's statements that he went to Whole Foods and CVS in Swampscott that day. Defendant's false statements to police and concealment of information contributed to probable cause analysis of whether he was involved in the crime. Additionally, police discovered several internet searches made following Anna's disappearance on Brian's son's iPad mini regarding ways to dispose of a dead body and clean up a crime scene. Taken together, this information was sufficient to establish probable cause to believe that the defendant was involved in Anna's disappearance and was misleading the police and therefore had committed the crimes of kidnapping and misleading a police investigation.
The affidavit also established a nexus between these crimes and the items sought in the warrant, including physiological evidence, items belonging to Anna, such as her clothing, jewelry, passport, wallet, cell phone, electronic devices, and instruments of the crime as described in the warrant application. It is reasonable to infer, the court says from the affidavit, that Brian, the only adult in the home at the time of the internet searches concerning the dismemberment and disposing of and the cleaning up after a dead body occurred, performed these searches. Thus, there was probable cause to believe that physiological evidence would be found in the Walshe residence, as well as the tools and cleaning supplies necessary to perform the actions identified in the internet searches. The affidavit also explained that Brian was using electronic devices to make internet searches directly related to Anna's disappearance and to communicate about her disappearance in the time before police were aware that she was missing. Therefore, there was probable cause to believe that there would be evidence of the crimes on the devices. And they cite a Massachusetts case. Further, where there was no evidence that Anna had left the home and her phone pinged in the area of the home after she went missing, there was probable cause to believe the clothing she was allegedly wearing when she was last seen and her passport, wallet, and cell phone, as well as the other items sought in the warrant, would be found in the Walshe residence. Accordingly, the defendant's first contention fails.
With regard to defendant's second argument, the warrant's authorization to seize all electronic devices in the residence was not impermissibly broad. The fact that the internet searches about dismembering and disposing of a body appeared on the defendant's son's iPad mini is significant. It was reasonable for police to infer that Brian made those searches either on his son's device or another Apple device synced to that iPad. In either case, officers could further infer that Brian used various electronic devices to which he had access in an effort to cover up his crime. And then it cites a case, and it says, where evidence could thus have existed on any or all electronic devices at a location associated with the IP address, the seizure of over a dozen electronic devices found in the apartment did not exceed the warrant scope.
And that goes back to something that they pointed out earlier. I think it was Trooper Garino, the electronics expert, pointed out that, these devices all, they cross over. You put something on one and it bounces up and back down onto the other one, whether it's through the cloud or directly through Bluetooth or whatever. Anyhow, the affidavit set forth that Brian was using his phone as well as some of the other electronic devices to communicate about Anna's whereabouts. Brian told the investigators that while his phone was missing from December 31st to January 2nd, he had, now look at that, the court is kind of mixing up the dates. Look at that. They were pointing out that the officers were mixing up dates. December 31st, 2022 to January 2nd, 2022. That should be 2023. So,
oh yeah,
the rules that are good for one are good for the other. In any event, Mr. Walshe had emailed his mother and business partners to tell them Anna was missing. He further explained that upon locating his phone, he had texted Anna multiple times and reached out to her friends and her family to inquire if they had heard from her, and he had contacted Anna's work about not being able to get in touch with her. Thus, Brian was using more than one electronic device to communicate to and about Anna during the time she was missing. So he's thinking, oh, yeah, if I, instead of using my own phone, I use my 6-year-old kid's device, they'll never catch me. Wrong.
Based on the information in the affidavit, police had probable cause to believe that Brian was using electronic devices he had access to in the Walshe residence to affect the investigation into Anna's disappearance. Where the officers could not know which electronic devices held such information, the warrant authorizing the seizure of all devices was not overly broad. And then it cites a case law. And then, thus, defendant's second argument is also unavailing. Accordingly, there is no basis to suppress the evidence seized pursuant to the Walshe resident warrant. I just figured I'd read that last part.
Right. Good. No, that's fine. So now we get to the Volkswagen warrant. The defendant challenges the warrant authorizing police to install a GPS tracking device on the 2013 Volkswagen Beetle registered to his mother and parked in the driveway of the Walshe residence. The court agrees that there was no probable cause for this warrant. The surreptitious installation of a GPS device on a motor vehicle is a search or a seizure, and thus requires a search warrant. Warrants for GPS monitoring of a vehicle may be issued under the court's common law authority in circumstances where there is probable cause to believe that a particularly described offense has been or is being or is about to be committed, and that GPS monitoring of the vehicle will produce evidence of such offense or will aid in the apprehension of a person who the applicant has a probable cause to believe has committed, is committing, or is about to commit such offense.
The warrant at issue does not meet this standard. The warrant authorized the GPS tracking of the Volkswagen for 15 days from the date of its issuance, January 8th, 2023. However, the affidavit supporting the warrant did not offer any information as to how monitoring the Volkswagen would produce evidence of Brian's alleged kidnapping or Anna or his misleading of the police investigation or aid in his apprehension for such crimes. Other than stating that the Volkswagen was currently parked in the driveway of the Walshe residence and that Brian had access to and the ability to operate it, there was no information in the affidavit connecting the vehicle to Brian or the crimes. And this is just based on what is written in the affidavit. So right. He didn't put any facts to support it. So
I'm reading the footnote, and that's correct. And all the court does is look within the four corners of the document. You're not allowed to add argument or additional testimony or, oh, and by the way, I expected to put this in there. No, they go by the four corners of the. And I think we hit that about 27 pages ago.
While the affiant averred that having access to 3 vehicles suggested Brian may be a flight risk, there are no facts in the affidavit from which it can be inferred that Brian was considering flight, nor is it clear to the court how having access to more than one vehicle increases a suspect's risk of flight. Because the affidavit supporting the Volkswagen warrant was not supported by probable cause, the court will suppress any evidence obtained from that warrant.
Okay, so that particular warrant is stricken. So we move on to the electronic device warrants and the iPad warrant. During the execution of the Walshe residence warrant, police seized several electronic devices, which each became the subject of their own warrant. Much later in the investigation, police obtained the warrant for the iPad A1474, a device they obtained from Anna's residence in Washington, D.C. The defendant argues that, 1, all the affidavits supporting these warrants lack specific evidence linking the electronic devices to criminal conduct. 2, that the affidavits impermissibly rely only on the general presence of cell phones in daily life and officer experience. And 3, they are overly broad in terms of the time frame and the items sought. None of these arguments have any merit, officers.
And let's see why. Okay. To establish probable cause to search the contents of computer-like devices, police first must obtain information that establishes the existence of some particularized evidence related to the crime that they believe is likely to be found on the device in question. And then it cites some law which purports to hold There must be specific, not speculative evidence linking the device in question to the criminal conduct. The warrant affidavits at issue here meet this standard.
Turning to the defendant's first contention for largely the same reasons as stated in Section 1, discussing the Walshe residence warrant, the affidavits for the electronic devices warrants contain sufficient specific evidence linking Brian's electronic devices to the accused of criminal conduct. The affidavits explained that on the day Anna went missing, Brian utilized an electronic device to conduct internet searches about how to dismember, dispose of, and clean up after a dead body. That in the days after Anna's disappearance, Brian utilized more than one device to send emails, text messages, and/or make phone calls to Anna, her friends and family, and her employer about her disappearance. That police knew Brian was giving them false information about his whereabouts based on location data and other evidence showing he was not where he said he was, but rather was purchasing materials they suspected would be used in the furtherance of his crimes, and that after the police had commenced their investigation, they received a suspicious ransom email from someone claiming to be holding Anna. Total phony, by the way. The affidavits also explained how Apple electronic devices can share information such as internet searches across devices and how they can store information related to a device's location, distance traveled, and time remained at various coordinates. Health information such as heart rate, financial information such as purchases made, and incoming and outgoing communications. Thus, the affidavits established probable cause to believe that Brian's electronic devices would contain evidence of Anna's disappearance and Brian's efforts to mislead the police investigation.
As to the defendant's second argument, the affidavits did not, as he contends, rely only on general evidence about cell phones and officer experience. Rather, as noted above, they provided detailed information regarding how police believe Brian's used electronic devices in the commission of the crimes and why they believed the information sought would be on his electronic devices. And then they cite a case law which holds that the affidavit did not provide probable cause to search the defendant's cell phone where the only connection between the cell phone and the crime was the affiant's conclusory statement that cellular telephones contain multiple modes used to store vast amounts of electronic data, and that there was probable cause to believe that the defendant's cell phone and its associated accounts will likely contain information pertinent to this investigation.
This document reminds me of law school a little bit. I don't know how they taught you in California. I know here in the greater Boston area, they quizzically kind of beat around the bush. They don't come right out and tell you here's the law. They make you read cases. And this document is actually a great case that explains what is the law of probable cause, what are the requirements of a search warrant, what do you have to tell the court, how broad is the requirement that one specify probable cause, but then narrowing it down, how narrow do they have to get in particularizing the evidence that leads to that probable cause. So It's an interesting case. This is a law school kind of case. I don't know. Is that how they taught you in California too, by beating around the bush and just having you read cases?
Yeah, you'd have to extract the holding of the case,
Right.
You have to, at the end of the day, you just basically have to find out what the case stands for.
Right.
And the facts, the specific facts to that case. And yeah, it's IRAC, issue, rule, analysis, conclusion.
Absolutely. And this document follows that perfectly. It stated at the beginning, what is the issue? And in figuring out what the issue is, you state the facts. And there was a really long factual section. Then they stated the rule of law. We've done that, and we're kind of doing that now. But then you apply the law to the facts, and we're reaching conclusion, warrant by warrant. So it's IRAC 1, IRAC 2, IRAC 3, IRAC 4. Mm-hmm. So I'd like to think that our viewers, both on your channel, which is a great channel, and my channel, which I like to think is okay, I'd like to think that our viewers are either people that are interested in the law or people learning law. So this is a good case, and it's a Massachusetts case. but Massachusetts tracks the federal Constitution, if not taking it one step further and furthering the rights of those who are accused of crimes. So it's a good case, and it kind of states, the federal law as well as the Massachusetts law. So, rant over. With regard to the defendant's last contention, the items sought in the electronic devices warrants were not overly broad. To be sure, the warrants authorized the search of a significant amount of information from the devices. This included all communications, emails, texts, etc., browser search history, photos, videos, auto files, location data, text documents, health data, user data related to specific Apple IDs, and information related to the ownership, custody, and control of the evidence sought. However, the warrants were directed at information that police expected to find on the devices based on what they had already uncovered during the investigation. And they cite a 2017 case that holds that police had detailed and specific knowledge in that case concerning the defendant's use of a cell phone in commission of a crime, establishing probable cause to search the call logs and telephone contact lists of the 9 seized telephones in that case. Moreover, the warrants were limited in scope to items that related to the disappearance of Anna Walshe and misleading of the police investigation. And they cite Addendum A, Item A, which we're not going to get into, or related to Brian Walshe's activities regarding this investigation, Addendum A, Item C. As such, the warrants were clear about what they were seeking on the devices and specifically identified the type of evidence sought, and so were not overly broad in scope. And so they cite a couple of cases that, as we just pointed out, you got to take the law, apply it to the facts, and they've done that. And as I pointed out earlier, this is not only good Massachusetts law, but it's federal law, citing United States Supreme Court case that was cited in 2018, which, in view of the law, that's like yesterday, right? Something that's only that old from 2018, that's almost like yesterday.
Yeah, almost. Okay, the defendant's challenge to the breadth of the time frame similarly fails. To be sufficiently particular, a warrant for a cell phone search or other electronic device presumptively must contain some temporal limit. They cite Snow, which holds determining the permissible parameters for a cell phone search is a fact-intensive inquiry and must be resolved based on the particular facts of each case. The inquiry can be based on the type of crime, the nature of the evidence sought, and normal inferences about how far back in time the evidence could be found. Here, the time frame was within permissible parameters.
The electronic devices warrants were limited to the time between December 25th, Christmas Day of 2022, and January 8th of 2023, or in the case of the health data from December 31st, 2022 to January 8th of 2023. Based on the facts of this case, there was nothing overly expansive about these timeframes. As to the time period between January 1st of 2022 and January 8th of 2023, the affidavits articulated a reasonable belief by police that Brian was engaging in efforts to mislead the police in their investigation into Anna's disappearance by, among other things, giving police false information about what he was doing and where he was going during that time period and engaging in efforts to get rid of evidence. So again, notice that the court kind of, they kind of messed up those dates. See there where they're saying January 1st of 2022, that should be January 1st of 2023. So where they gave a footnote spanking to the police for having the wrong dates, I'm going to say that the court clerks failed to catch this one.
Yeah.
Moreover, Anna's body had not yet been located, and as discussed herein, police had reason to believe that evidence of what happened to her and Brian's actions since her disappearance would be found in the specifically articulated evidence sought on his devices.
As to the days prior to January 1st, 2023, police had reason to believe that Brian and Anna were having marital troubles before her disappearance. The affidavits noted that although Brian had told police that there was no marital discord between him and Anna, on December 27, 2022, Brian had searched for quote, best state to divorce for a man, unquote.
Oh boy.
Moreover, the affidavits explained that Anna had come back to Massachusetts around Christmas, then gone back to DC, and then returned again to Massachusetts right before December 31st, 2022. Given the general use of cell phones as articulated in the affidavit and Brian and Anna's relationship, it was reasonable to infer that there would be communications between them leading up to New Year's Eve. There was therefore probable cause to believe evidence as to the reasons for Anna's disappearance would be found in the days leading up to January 1st, 2023, and the inclusion of the 5 days prior to Anna's disappearance as part of the temporal time was not overly expansive. And then they cite the Henley case again, which holds where a record showed long-standing relationship between the defendants and the victim, reasonable temporal limit for cell phone search would extend beyond just the day of the murder or even the days leading up to the murder. Where the tenor of the parties' relationship is critical to the claim, it could be reasonable to look back further in time.
So that defines, what a reasonable period of time. They use the word temporal. All that means is that, you got to have a reasonable time limit. You can't say from, the beginning of time until the end of time. I mean, you've got to state a time period. It might be a short time period. It might be a long time period, but you've got to explain to the court why you have the beginning date and why you have the end date and why you are seeking that time period. It's got to be a lot of stuff in the law, including this, all boils down to being reasonable and explaining yourself.
If the explanation is confusing, sometimes a judge will want clarification. I know of a criminal judge that frequently asks for clarification and the affidavit is modified,
Yeah, they'll ask for that. Absolutely. Mm-hmm. Although the defendant makes no specific argument as to the iPad A1474 warrant, there's no question that warrant was also supported by probable cause. Police obtained the iPad A1474 warrant on March 9th, 2023, well into the investigation, and as such, it contained more evidence supporting probable cause to believe that Brian had killed and dismembered Anna's body and misled police about what had occurred, and more information about what had been found on Brian's electronic devices already searched. The iPad A1474 warrant primarily sought communications or records contained on the device between Brian and Anna relating to their states of mind or motive, as well as browser history, location data, and other documentary evidence related to Anna's disappearance and murder. To the extent that the defendant is challenging the expanded time frame of this warrant from November 17th, 2022 to January 7th, 2023, given the evidence police had implicating Brian in the crimes as articulated in the supporting affidavit, there was a substantial basis to believe that the evidence relating to the crimes would be recovered in the expanded time frame. So that illustrates the point that I was trying to make before that, and the court did it better than me, obviously. You can have any time frame you want. It's just that you've got to explain it. And where you're talking about a crime of this nature, allegedly between a husband and a wife, you can go back a little bit further than they did previously.
Right. Now we come to the Verizon warrant affidavits. The defendant challenges the 2 warrants for Verizon records pertaining to the CSLI and location data for the 2 iPhones he used. He contends that the time periods requested for the data from December 30th, 2022 through January 8th, 2023 for the number ending in 8646, and from January 1st, 2023 through January 8th, 2023 for the number ending in 8028 are unreasonably large and amount to an unlawful general warrant. The court agrees with defendant only to the extent that the Verizon 8646 warrant sought CSLI data for December 30th and 31st, 2022. The time periods sought were otherwise permissible.
An affidavit in support of a search warrant for historical CSLI must demonstrate probable cause to believe that a particularly described offense has been, is being, or is about to be committed, and that the CSLI being sought will produce evidence of such offense or will aid in the apprehension of a person who the applicant has probable cause to believe has committed, is committing, or is about to commit such offense. The Supreme Judicial Court, the highest court in Massachusetts, has recognized that defining the permissible parameters of time for CSLI searches that are justified by probable cause is difficult. This is a fact-intensive inquiry and must be resolved based on the particular facts of each case.
There is no question here that the affidavits supporting the Verizon warrants provided probable cause to believe the defendant had committed the crimes alleged. The affidavits contained additional information regarding Brian's purchase of tools such as a hacksaw, police observations of Brian discarding items in various dumpsters, items police recovered from the Swampscott dumpster, Brian and Anna's estranged relationship, and Brian's attempt to mislead the investigation into her disappearance. The affidavits further stated that Brian used both cell phones during the relevant time frame when Anna went missing and the police commenced their investigation. Where cell phones have become an indispensable part of daily life and exist almost personal attachments to their users' bodies.
There's that quote I'm sorry to interrupt you, but there's that quote we were talking about at the very beginning that cell phones have become almost permanent attachments to our bodies. That's crazy. I'm sorry.
Yeah. It may generally be inferred that the location data from a particular phone will yield the suspect's location at any given time. Therefore, an affidavit establishing that a suspect committed a crime and that the suspect was known to own or use a particular cell phone provides the requisite basis to believe that location data will provide evidence of a suspect's participation or lack thereof in the suspected criminal activity. Interesting.
I'm sorry.
I said interesting.
Yeah, it is interesting. The court is, bringing us all up to date that, we can assume that a phone is with a person unless there's some other evidence, unless there's evidence that, is irrelevant in this case, that, maybe the person forgot the phone, maybe they were way out in the woods where there's no cell coverage, and those areas are getting smaller and smaller. The court commented that, it can be inferred that the location data is pretty much going to tell you where the person is unless there's contrary evidence, and there's nothing like that in a probable cause affidavit.
But what if somebody steals your phone?
Well,
and commits a crime.
That happened to somebody that I know very recently. And obviously you can go down to the Apple store or the Android place or wherever you go and have that phone shut off immediately. That happened to me one time. I lost my phone and I retraced all my steps. I realized about 10 o'clock in the morning that I didn't know where my phone was. And I retraced all of my steps, going to a couple of different places, walked the dog. I retraced every step that I made, couldn't find the phone. And that's when I learned that if you go to, at that point, the Apple store and talk to them, they can actually shut your phone off. But that, obviously there was a period of time from the time I lost the phone, which I didn't know, until they shut it off. But they can deactivate that phone. So someone that finds that phone, can't use it. It's just, you're not usable. And the scariest part of it is that all of my personal stuff was up in the cloud. And once I paid for my new iPhone, it all came back. Isn't that scary? That you can wipe your phone all you want, like Mr. Koberger did. You can wipe your phone all day long, but it's all up there and it can be brought back down again for your own personal use or by law enforcement. So
interesting.
We're veering away from the point here. And the point here is to figure out, what is required in an affidavit to show probable cause. And at the same time, how particular do you have to be with regard to the information that you're seeking? And that's an interesting balance. Insofar as the warrant sought CSLI data from January 1st, 2023 to January 8th of 2023, the time frame was not impermissibly expansive. The information in the affidavits outlined Brian's actions from January 1st, 2023 to January 8th, 2023. During that time, Brian bought tools and cleaning supplies that could be used to dismember, dispose of, and clean up after a dead body. January 1st and 2nd, went to dumpsters at various apartment complex to discard bags. January 3 and 5, including at his mother's complex, where police recovered items belonging to Anna and items stained with what appeared to be blood. Further, during interviews with investigators, the last of which occurred on January 7th of 2023, Brian continually gave police false information about where he had gone in the days after Anna's disappearance, and police still had not recovered Anna's body as of January 8th of 2023. Given that police had probable cause to believe Brian was responsible for Anna's disappearance on January 1st, 2023, and that he had spent the days between then and his arrest attempting to cover up his crimes and mislead the police investigation, there was probable cause to believe location data from Brian's phone records for January 1, 2023 through January 8th of 2023 would yield evidence of his involvement with the crimes. And they cite a 2017 Massachusetts case concluding that probable cause supported CSLI warrants, where the affidavit established that the defendant had a cell phone that was in use around the time of the crime, which there was probable cause to believe he had committed.
However, with regards to the additional 2 days of CSLI, December 30th and 31st, 2022, sought in the Verizon 8646 warrant, there was no probable cause to believe that CSLI data from those dates would contain evidence of the offenses. The affidavit explained that Mutlu told police that he last saw Anna around 1 a.m. on January 1st, 2023. There is nothing in the affidavit suggesting that police had any reason to believe that a crime occurred before that point. Thus, there was no substantial basis to believe that the device would contain relevant evidence of the crime, that is, the defendant's location at or around the time the crime was committed.
We're getting to the end, folks. We're getting to the end. Thank you for bearing with us if you have. We really appreciate it because we're almost there. Because there was only probable cause to support Verizon warrants for the period of time from January 1st of 2023 through January 8th of 2023, the court will sever the Verizon 8646 warrant and suppress any CSLI and location data obtained for December 30th, 2022 and December 31st, 2022. And they cite a 2020 case in which severance of the valid portion of a search warrant where a part of the warrant was proper remedy for overly broad CSLI warrant allows the court to perform surgery. And part of the materials that are sought are okay. Part of the materials are not okay, just like performing surgery, and they cut it apart. So, Yoli, you get to read the final conclusion and order.
All right. For the foregoing reasons, defendant's motion to suppress is allowed as to search warrant number 23SW0035 for GPS install on a 2013 Volkswagen Beetle, and it has a registration number. It is also allowed as to search warrant number 23SW76 for Verizon records of cell phone number 617-939-8646 insofar it authorized CSLI and location data obtained for December 30th, 2022 and December 31st, 2022. The motion to suppress is otherwise denied.
Interesting. Aren't we always told that PII, personally identifiable information, is supposed to be redacted? So I found it unusual.
Yeah, that they have the number?
Yeah.
Well, I guess they're not in use anymore, those phone numbers, so. Yeah. I bet if you tried to call it, you wouldn't get anywhere.
It might have been sold. It may well have been sold to somebody else. I mean, there's only so many numbers. And people have multiple numbers. I know people that have multiple phones. And so I was just surprised by that I think somebody just forgot to, even though you're right, it's probably not in use anymore. But I've always been told the PII is not allowable. And, throughout this memorandum and order itself, we've seen only the last 4 digits being used. And so it's signed by Diane Frenier, the judge. That's interesting. I found the thing interesting. I hope that our viewers have found it as interesting as I have.
I found it interesting.
A lot of people, question, wow, can you defense attorneys do this or that or the other? And it's like, it rises to constitutional proportions. Anyone accused of a crime until they're found guilty by a jury of their peers or a judge, if it's a bench trial, is entitled to a presumption of innocence, and they are allowed to have the best defense possible. But the other thing is for a defense attorney not to bring motions to suppress can be viewed as malpractice. It can be viewed as ineffective assistance of counsel if the defendant doesn't win the case. If the defendant is found guilty, the appeals court is really going to look very carefully at what was done. And if as the attorney you did not bring a motion to suppress, you better make sure your malpractice insurance is paid up. But you also no attorney wants to have a motion for a new trial or for an appeal based on ineffective assistance of counsel. I mean, it does happen. I mean, I've known defense attorneys, very good defense attorneys, and if somebody's sitting behind bars for a long period of time, that's just one of the things they're going to say, whether it's true or not. That's one of their allegations. But so I found it interesting. I also found it interesting that it went on for so many pages. And if you've followed us for the whole thing, thank you. Because the judge doesn't want to be overturned. The judge, I thought that it was very thorough, followed the pattern that you pointed out, the IRAC pattern, and, affidavit by affidavit, warrant by warrant, went through that analysis. And so it's a good decision for people to take a look at, both for, structure, but for the substance of the law on probable cause and particularity of that's my take on it. What's your take?
Yeah, I thought that it was very well written, and it explains things in a manner that is the way you're supposed to write, which is issue, role, analysis, conclusion. So I think it was very well written. Kudos to the judge.
Yeah. So now my next question is that my crystal ball is broken, but I'll ask you, if you have a crystal ball, do you think this will be like the Koberger case, where in the very end, very end, he took a plea? Do you think that'll happen with Mr. Walshe?
Well, Mr. Walshe has been talking. He's been talking a lot, or he did talk a lot. So usually when people talk a lot, they go to trial. I don't know why that is. I've just noticed that. So I think this will probably go to trial. Although, I don't know, in the Madeline Soto case, Stephen Stearns pled guilty.
Yes, he did.
But I believe he did a Alford plea on some of the counts. I don't remember. But I don't know. It just seems like these people, like the Daybell case, I don't know. It just seems like when people speak about or try to cover up their crimes, and by talking about them, that a lot of times they go to trial. And so I think this Brian Walshe, he may just want to go to trial as opposed to pleading guilty. But I don't know.
Well, the interesting, I don't know. Like I told you before, my crystal ball is broken. I'm glad yours is working to a little bit of an extent. But to be a little bit more serious about the whole thing, the little piece about the DNA, I mean, you can explain away going to the hardware store and buying a tarp. I bought a new tarp when I was having a mulch delivery because I didn't want to mess up my driveway. But, 2 12-pound bags of baking soda, the overalls the Tyvek suit that he bought, you can tortuously explain away all of those things until you get to the actual body fluid DNA that was found. That's a bad thing. Of all the 36 pages that we just read, that really stands out in my mind. Put it in the context of all of those searches, which I'm not going to laboriously go back over. It doesn't look good for Mr. Walshe, but he is entitled to a trial. He is entitled to a presumption of innocence. Make nasty comments down below all you want. You lawyers this, you lawyers that. I'm used to it. I read it. But the difference between this case and the Koberger case was a lot of people say he took the plea because he wanted to get the DP off the table. So instead of getting the DP, he'll sit in jail for the rest of his life. Massachusetts doesn't have the DP. So there's not that impetus.
Right.
So as bad as things look, and again, I'm granting Mr. Walshe the benefit of the presumption of innocence, why not go to trial? You never know what a jury is going to do. Any trial attorney you talk to who is being honest will tell you that going in front of a jury is a roll of the dice. So,
and you also have an officer that was investigating the case that has gotten fired for misconduct.
yeah,
I don't know if that would come in.
Well, I don't know. There's a motion. There is another motion that is now pending and will be argued in the very near future in this case to get all the federal documents back down from the federal government. The 3,000 pages of FBI documents that had been given to both the prosecution and the defense in the Karen Read case were only given to both of the sides on the strict condition that they read the documents. They couldn't really talk about the documents. They could use the information that was in the documents. But at the end of the case, they had to send all of the documents back to the federal government, not retain any copies, and make no further use of them. So there's a motion pending in the Brian Walshe case to get all of those documents.
Yeah. So why not go to trial, right? I mean,
well, yeah, that's what I'm saying. Why not go to trial? Proctor, the funny thing about this case is that it would seem that for the most part, not entirely, but for the most part, the Massachusetts State Police did conduct a thorough investigation, and they did go to the court, and they did get correct warrants, with the exception of a couple of the things in the telephone warrants, and with the exception of placing the GSI device on his mother's Volkswagen. Those motions to suppress were allowed. But so it kind of speaks oddly about the MSP, where they know how to perform a correct investigation, but they screwed it up royally in the Read case, which, you know, people say, well, was it incompetence or was it intentional? The fact that they did it for the most part correctly in this case tends to make us all believe that it was an intentional botch in the Read case. It was intent that they did what they did. It was an intent that they pinned it on the girl, when I think they probably knew full well that the girl, I'm sorry, Karen, didn't have anything to do with it.
Right. And then the dates, the erroneous dates on the affidavits, maybe that was explained in a prior hearing. I don't know that, but you know, I don't know what effect that would have on anything, if like on an appeal or something, but maybe it was explained.
I would have to go back and look at the hearing, because again, the hearing on these motions to suppress were on June 18th of 2025, the same day we were all watching the Read verdicts, and then the huge celebration outside the courthouse. That's the only word for it. And so it does seem to me that a lot of us overlooked the hearing. I was guilty of that. I did go back and watch it the next week, and you know, I was still focusing a lot on the Read case. And so I would, to answer that question, I would have to go back and look at the hearing. It's possible that there were honest mistakes. It's possible that they were answered during that hearing. In fact, I'm going to wisely guess. That's another way to say it, an educated guess, that that's the situation.
Okay.
So what's ahead in this case? Let's go forward. August 12th, which is coming up and probably has passed by the time a lot of people are watching this. August 12th, there's a scheduling conference. October 7th is the final pretrial. And then the trial, as we sit here today, subject to change, the final trial is scheduled in the Brian Walshe case on October 20th in the Norfolk County Superior Court. So that's what lies ahead. Any closing thoughts for us, Yoli?
No, interesting case. It's kind of morbid, but
oh, if you think this is nothing, there's a lengthy, and I forget how many pages, even more than this. There's a statement. It reads like an indictment, but it's not an indictment. What it is a statement of the case by the prosecutor, and it goes on and on and on, and we're not looking at it today. But if anybody really is seriously interested in the case, it goes into much more detail, which we only glossed over today, believe it or not. So Yoli, at the end of our episodes, we generally ask people if they've been with us for the whole thing, and I'm surprised how many people are. And thank you. What kind of an emoji should we ask them to drop? How about an iPad or an iPhone or something like that?
There you go. An electronic device.
An electronic device. There you go. Okay. Thank you, folks. Please, in the comments, be nice, be respectful. If you don't agree with somebody, start your own string and say why you think the way you do. Please don't disparage other listeners. Just because you don't agree with somebody doesn't mean they're a bad person or a moron or what. Please be nice. Whether you're in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.